Okay. Hi, everybody. Welcome to tonight's webinar on changes to Michigan no-fault auto insurance. Hopefully you can hear me just fine. I will ask you just to start out kind of housekeeping. When you joined in our webinar tonight, this technically is a Zoom meeting. And if your Zoom settings are set up so that when you join a meeting, your camera is defaulted to be on, we can see you. And so we would request that if you are on the computer, and you can go down into your lower left-hand corner and you'll see the video camera down there. If you can press on that, it will put a red line through it and it will turn off your camera. You are already muted, so you don't have to worry about muting your phone. But as people are joining, I don't want you to get distracted by the latest person popping up. God forbid we see something that we shouldn't or don't want to see. So just a reminder, your camera could be on without you knowing it. And so in the lower left-hand corner, you can click that video camera and that should turn your camera off. So again, I'd like to welcome everybody to tonight's webinar on changes to Michigan no-fault auto insurance. I'm excited that you decided to invest some time tonight to better educate yourself, or maybe just confirm some things that you've already learned about changes to car insurance coverage in Michigan. The goal tonight is simple. Tom and I would like to know that when you leave tonight's webinar, you feel more comfortable with the changes to the law and how those changes impact you. Ultimately, we hope that you will know more about how to best protect yourself, your family, and or your business after tonight's webinar. For those of you that don't know me, my name is Mike Salisbury, and I own a small independent insurance agency here in West Michigan. I say independent because our agency isn't affiliated with just one insurance company. But if you recognize names like Auto Owners Insurance, Progressive, Pioneer State Mutual, or Foremost, just to name a few, those are some of the brands that we offer to our clients. Our agency started protecting people more than 100 years ago, and for the past 21 years, I've had the privilege of carrying on the Reno family name and protecting families and small businesses all over Michigan. I've studied the changes to the law since last June, and I feel extremely comfortable how all of us will transition from the only system that most of us have ever driven under to something that is entirely unique to Michigan. I'm also extremely excited to introduce our keynote speaker, one of Michigan's legal experts in Michigan's no-fault auto law, attorney Tom Sinas. Tom Sinas is a trial lawyer who has spent his career serving the public and advocating for the injured. As a partner at Sinas and Dramis law firm, he manages the firm's downtown Grand Rapids office and is dedicated to serving his home community of West Michigan. When Tom opened the Grand Rapids office, the law firm founded by his grandfather, the goal was clear: bring the firm's tradition of excellence in personal injury law and community service directly to West Michigan. That first meant leaving a prestigious career as a trial lawyer in Minneapolis and relocating his family to Grand Rapids. It next meant becoming deeply involved in community and professional endeavors. Tom brought the Lids for Kids program to Grand Rapids, which has resulted in nearly 3,000 West Michigan children receiving free bike helmets. Tom also co-hosts Know the Law on Fox 17, a weekly television segment that educates the public about laws that affect their everyday lives and legal rights. Tom has held leadership positions in organizations such as the Brain Injury Association of Michigan, the State Bar of Michigan, the Grand Rapids Bar Association, and the Legal Assistance Center. He has also received numerous professional accolades, including being recognized as Michigan Super Lawyer, a Grand Rapids Top Lawyer, and a Top 10 Professional Injury Plaintiffs Lawyer by Leading Lawyer magazine. Most importantly, Tom has achieved justice for his clients, having obtained some of the firm's largest personal injury settlements and verdicts. So we welcome and thank Tom for leading tonight's presentation. I just have a couple of housekeeping issues before we turn the presentation over to Tom. Like I said, your microphone has already been muted, so you don't have to worry about us hearing your barking dog or crying baby or whining teenager. If that's more the case, Your camera, we ask that you turn off, especially if you came to the meeting and your Zoom settings, and they probably are set to just see the camera right away, just so that doesn't distract Tom or any of the other attendees. As you're listening to Tom, if he says something confusing, and there will be lots of this, you're able to text a question to me. You can do so by clicking the chat option, which is likely at the bottom of the screen if you're on a computer. If you're watching on your phone or you simply dialed in to the conference call, you can also email mike@renoagency.com. Some of you have already done this, and we'll share those questions with Tom. Tom and I will address your questions after his presentation. Your questions are confidential, by the way. None of the attendees will see them. I'm the only one that will see them. So remember, like your high school teacher used to tell us, there's no such thing as a bad question. When you open up the chat window, you won't see any questions there. So please ask questions. It's very likely that something you're wondering about, someone else in the room is also wondering about. Lastly, and Tom, I don't know if we did this yet, but Tom is going to provide a link in the chat window to a free publication that he and his firm have offered, and it's on their website. It's a PDF file that you can download during our meeting tonight. I encourage you to do this. It'll open up in a separate window. It's not going to mess up the webinar or anything like that. It's a great resource all by itself if you were to just read it by itself without coming tonight, but hopefully you can use it to review after Tom's presentation to confirm or clarify some things that you might have heard tonight. So I'm going to ask Tom and then Alicia and Megan, who's also on our team, is there anything that I have forgot to mention at this point, guys? You can either send me a text or go ahead and speak if your mic is on.
I think you covered it, Mike.
Okay. Well, then without further ado, I'm going to go ahead and turn over the virtual floor to Tom Sinas, Grand Rapids attorney from Sinas and Dramis. Thanks so much, Tom.
Thank you, Mike, and thank you everybody for being here. I'm heartened to see the number of people who are on this call because this is something that obviously matters to all of us. You know, usually when I give talks like this, I'm giving talks to other lawyers or maybe people in the legal or medical field. But what's really satisfying about this is being able to talk to all of you. What's a little hard about this is that it's a bit of complicated and, in my estimation, sometimes troubling news that I have to share with all of you, because this is something that affects all of us. And I'm sure that's why you're here and on a beautiful evening, because you want to try to make good choices for yourself and good choices for your family or your business. And that really is the goal of what we're doing. As Mike said, I did send everybody a link to a document that is actually entitled Making Smart Choices. It's in the chat feature. If you have a hard time getting it out of there, just Google my name or Google the firm's website and you'll see it right there on the home page. Please feel free to share it with anyone that you think might be interested. So what I'm going to do now, I'm going to start sharing my screen. I just have some slides to kind of accompany what I'm going to share with you tonight. I'm not generally a PowerPoint fan because people read their slides. So my goal here is not to do that, but to give just something to look at to help guide our discussion. So let me switch over here, make sure that everybody can see that. Mike, you're muted, so he'll tell me if you can.
Yep.
Sounds good. Okay.
You can absolutely see, can hear you great.
Okay, great. So again, I'm plugging the written materials not because they're written by our firm, but because I am a believer that you learn things when you have them reinforced different ways. So hearing about this is helpful. Reading about it makes it all the more helpful. Talking about it helps really solidify it. So if you do those three things, you'll be well on your way to understanding this issue, and you'll hopefully be able to help this endeavor that we're undertaking here, which is to educate other people about a decision that is really important to them. I hope it's something that they never really have to concern themselves with, meaning I hope they never have to have a serious claim under Michigan's auto insurance law. But if they do, we want to make sure that people have made a good choice before that happens. So I want to start at a very general level here and ask the question, what problem is it that we're trying to solve? I've asked this question to other groups and people have said, oh, we're trying to solve insurance premiums or medical care costs, or charging people different amounts of premiums based on where they live. It's much more general than that. By the problem we're trying to solve, I'm referring to this. This happens, sadly, all the time. Serious car crashes have always happened, and as best we can tell, until technology finds ourselves a way out, they're going to continue to happen. And this begs the question, what are we going to do about this thing, a car crash, that happens over and over and over again? It is one of the most likely ways that people will be seriously hurt. And it happens with such regularity that the legal system, for almost as long as cars have existed, has struggled with this question: how are we going to deal with the various harms that follow a car crash? Because there are all sorts of harms. There's the obvious ones that you see in the picture. There's the damage to the vehicles. And then there are the ones that are more important. There are the damage to the people involved. And when those people are harmed, they seek out things like medical care, or they miss time from work, or they have serious physical injuries that affect their quality of life. All of those things are harms that flow from any serious auto accident. And what we in Michigan have tried to do is come up with a system to deal with those harms and to deal with it in a way that is maybe more efficient or different than we would deal with something else that doesn't happen as frequently. That's really why we find ourselves in the world of auto insurance. So I don't want to spend a lot of time on memory lane, but I want everyone to know where we were for 40 some odd years, I guess. From 1973 to 2019, in Michigan, we had a specific and very unique way of dealing with the harms that flow from an auto accident. And I reference this because I think you have to understand the old system in order to understand the new. I've tried to speak to people about the new without touching on the old, and immediately I think people's eyes go cross-eyed or gloss over because there's so much technical jargon that gets interspersed in these discussions. So I'm going to go back and give us a reference point that you'll see flows through in helping us understand the changes for today. So I always explain it this way to my clients. Before 2019, we dealt with the harms that flow from an auto accident in a two-handed system. Of course, the law doesn't call it a two-handed system, but practically that is how it worked, meaning that people who were in automobile accidents had two different sets of rights. One set of rights in what is my right hand, the other set of rights in what is in my left hand. And their hands, so of course, they work together, but they work independent of one another, or at least they did. And one of the defining features of the no-fault law before last year was that if you could get something in one hand, you cannot get it in the other. So that meant that if you were looking for a particular form of harm that flowed from an auto accident, you'd figure out what hand it was in, and you knew that that was the hand that you went to for that particular harm. You didn't have to worry about finding that harm in the other hand. So what is the right hand? Again, I'm never sure on a webcam whether the hands get switched, but this is my right hand, and I'm going to refer to it as the no-fault hand. People also call this the PIP hand, P-I-P. Some people call it the first-party hand. I don't think it's helped this discussion over the years to have all these synonyms for the same concept, but they're out there, and so if you've used those words, I'm talking about the same thing. So this is my right hand, and what was in it? Again, before 2019, what was in it? Well, the thing, and probably the reason that you're here, the thing that was in this hand is what the law calls the allowable expense benefit. Now, you probably think of it or heard of it as the medical benefit. And what was so significant about this, and so unique to Michigan, was that these allowable expenses did not just cover a hospital ride or surgery or inpatient therapy. It covered all of that, And it covered everything down the line from that, all the way to in-home attendant care or guardianship, or medical transportation or housing accommodations. It covered all that, and it covered it for every victim of an auto accident. It covered that for life, meaning it wasn't limited by a certain dollar amount, and it wasn't limited by a certain time period. If you were entitled to receive these benefits, meaning if you were not disqualified, everyone got the same unlimited benefit in that hand. The second thing in that hand is what we call the work loss benefit. This is different than the medical benefit because it's not unlimited, meaning it ends. It ends at a certain point in time, which is 3 years. And it is also and has always been subject to a monthly statutory cap that adjusts every year. The third thing in the hand is the smallest of the three. It's called the replacement services benefit. It's very small, $20 a day, designed to replace the everyday household chores that an injured person cannot do because of their injury. And the fourth thing on this slide really is not a separate benefit, but it's a unique benefit in cases of death. It really is designed to replace the economic loss caused by someone passing away from a motor vehicle crash. So that's the right hand, or that was the right hand. Okay, what's the left hand? Remember the old rule? If you can get it in one hand, you can't get it in another. So the left hand is what some people call the tort hand, or the tort liability hand, or the third party claim, or the bodily injury claim. Again, more and more synonyms for the same concept, making it more confusing. The essence of this claim is a claim against the person who caused the accident. Or as we say, the at-fault driver, or with more legal speak, the tortfeasor, the person who caused the accident. So what's in the hand? Meaning if you're the victim of a negligent driver, what was in the hand? What could you pursue? Well, I'm going to give you a pop quiz, and I know you can't answer it. Could you pursue medical expenses in the tort hand? No, because again, you get that over in the other hand. What about lost wages? Well, remember the first 3 years came over here. So that meant that any lost wage claim in the tort hand was wages beyond the first 3 years. And then the big thing that was in the tort hand, and still is what judges and lawyers call non-economic damages, which I find to almost be an oxymoron of a phrase. It doesn't really help. If you turn on the TV, you see a lot of the TV lawyers talk about pain and suffering damages, but it's much more than that. So I think of it as quality of life damages. It's the very, I don't think, controversial fact that when somebody has a serious injury, various aspects of their quality of life change, and for many people change for a very long time. And that is the heart and soul, really, of the tort liability hand under the old system. Okay, who paid for the hands? Well, when it came to the no-fault hand, the general rule was that you went to your own insurance company. That's why we call it no fault. It didn't matter who caused the accident. When you needed the benefits in the right hand, you went to your own insurance company. There were some exceptions, and there still are, and we can talk about those in detail if there are questions along these lines. What about the tort hand? What if you had a claim against the at-fault driver? Well, who generally paid for that? The individual is responsible, but the source of payment is the individual's liability insurance, which is why if you look at your insurance declaration page, you're going to see a whole bunch of lists of things that you pay for. And one of the things you pay for is no fault, PIP, first party, same thing, that's the right hand. The other thing you pay for is liability, that is the left hand. All right, boom. This is a picture taken last summer at the signing ceremony on Mackinac Island with the governor and the legislators who, frankly, I don't think many of them read this bill. I know it took me weeks to even begin to understand it, but this is where they celebrated this supposed achievement. And this event took place on Mackinac Island, but the law that you see held up here went into effect on June 11, 2019. And the minute that it did is the minute that this two-handed system, and I'm not saying it's perfect, there certainly were criticisms and there were flaws, but it is fair to say that this old two-handed system that we have really went up in smoke that day. You're here because you want to talk about the decisions that you're going to need to make right now. And the reason that you're making these decisions right now is because this law that was passed made a series of changes to our auto insurance system that phase in over time. Some of those changes became effective last year, June 11, 2019, when the law went into effect, and many of them are coming into effect right now, as of July 1st of 2020. There's another round of changes that are scheduled to come into effect in 2021. So there were a few that came into effect over the last year, and they have affected some people already, and some people have not seen these effects. But I want to touch these really quick because you'll see these concepts percolate as we talk about the decisions you're going to have to make now. One of the main changes, or one of the most significant changes, I think, from a consumer standpoint, was that as of last year, out-of-state residents became completely disqualified from receiving these no-fault benefits. So the out-of-state resident folks lost the right hand. Before this law, oftentimes out-of-state residents were able to receive no-fault benefits through different ways. But after this law was passed, out-of-state residents received none, which means that the things that were in this right hand, namely the out-of-state residents' often lifetime medical expenses, meaning that all of a sudden out-of-state residents were not able to recover those from their no-fault insurance. And what it meant is that out-of-state residents now can pursue claims against at-fault drivers for the first dollar of unpaid medical bills because they have no-fault coverage. The law made changes and made limitations on the ability of certain people to claim this right-handed no-fault benefit claim. And this is a little wordy, uninsured occupants and non-occupants. Another way of saying that is the law made changes to those people who are not covered under their own insurance policy or don't live with a relative who has an auto insurance policy. For those people, and of whom there are many, those people were no longer able, they are no longer able to draw their no-fault benefits the way that they could in the past. And instead, they have to receive benefits through a different system, a different part of the system, really, called the assigned claims plan. Some of you may have heard of this. This is the place where people used to go who were entitled to receive no-fault benefits, but couldn't find any coverage within the fact pattern of the accident. So they went to this place called the assigned claims plan. And when they got there, they too, like everyone else, were entitled to receive those lifetime medical expenses. Well, what this law did is it said if you don't have insurance of your own, whether yourself or a family member, you cannot draw unlimited medical expense coverage anymore. You have to go to the assigned claims plan, and when you get to the assigned claims plan, you're going to encounter a dollar cap. This was really the first dollar cap we've ever seen in the no-fault system since 1973 when it was passed. These folks now encounter a $250,000 limit. So who are these people? Well, it's the cyclist that doesn't own or insure a car. Or it's your elderly relative who doesn't own or insure a car because they can't drive, but yet maybe they live alone or maybe they live in an assisted living facility. Those people, they don't have their own auto insurance. They're no longer entitled to the lifetime benefit. They go to the assigned claims plan. Their benefits or their medical expense coverage are now limited to $250,000, which means, of course, that when they exceed that amount, where does the liability go? It jumps to the other hand. And we'll talk more about that in a minute. So I think of the new system, it's not written this way, but it's like a pay-to-play system. People don't get access to unlimited no-fault benefits unless they've somehow, either themselves personally or a family member, purchased an insurance policy. All right, well, here we are right now. And this really is the most significant moment in the no-fault reform, and it speaks to why you're all here. Because now we're at this pivot point that the law contemplated last year, where every Michigan motorist was going to be asked to make a series of what the people who supported the law called choices. And choices is a great word, right? We all want choices. We don't want to be told that we don't have a choice. We like to be told that we have lots of choices. But I pose this question: is it a choice or is it a guess? Because there's certain forms of insurance. I can go to Mike and I can say, Mike, I know that my home is worth this amount, but you know, I'd like to save a little bit of my premium, so I'm going to insure it to this amount, just a little bit less. And I'm going to take a risk. If it catches fire and it burns down, I know I'm going to eat the difference. Or even in the case of life insurance, I could say the same thing to Mike. You know, my wife probably needs X, or I need X if she passes away, but we're going to hope that we're healthy and we're going to insure ourselves to less than X. And if we're wrong, well, it's on us. That's a choice. But how do you make a choice when you are asking, will you be involved in a car accident? When will it happen? How will it happen? Who will cause it? Who will be injured? Will it be you? Will it be someone else? What parts of your body or someone else's body will be hurt? What type of medical care will you need? What type of specialist will you need to see? And so on and so forth. That's why I think it's a bit of a false narrative to say that this is about choice, because you're really just guessing. Now, I understand people say, well, you can look at the statistics in the aggregate and you can say, well, auto insurance claims usually don't exceed a certain amount. Well, that's fine. But you're looking at broader statistics. You're not making a choice about what you, of course, don't know, heaven forbid, you hope will not happen to you. Be that as it may, this is the menu of choices that people are being provided right now. And what do I mean by right now? Well, the law sets this date of the 1st of July of 2020, and it says for those people who have policies that renew on or after that date, they have to make choices about what type of coverage they want. So if your policy doesn't renew until September of 2020, you won't be required to make a choice until the policy renews. But if your policy renews on July 15th, you're going to have to make a choice about what you want to do from this menu at the time of that, by the time that renewal comes up. So this is the menu, and I'm going to go through some of the items in the menu. But before I do, I want to cover a few basic rules that apply to the menu. The first is when we're talking about monetary caps, because you'll see, if you haven't already, that we're now in a system where we're contemplating people purchasing policies that limit the amount of medical expense coverage. When we're talking about those caps, we're only talking about caps on the allowable expense benefit. Remember I said earlier, in the right hand, there was the allowable expense for medical coverage, the wage loss, and the replacement services. We're only talking about caps on the medical component. And when we're talking about caps, we're talking about caps that apply to each individual person who may have a claim under the policy, not a cap that applies to everyone. So what does that mean? Well, I have 2 kids and I'm married. So if heaven forbid the worst thing ever happened to us and all 4 of us were involved, I'm not going to pick a capped policy, but let's just pick on me. If I picked a capped policy of say $250,000, then the $250,000 cap would apply to me, a separate one to my wife, a third one to my son, and a fourth to my daughter. In other words, it's not $250,000 to divide amongst the 4. What about premium reductions? Well, people have heard a lot about how this is going to bring down the cost of premium. And it may, or it may not. The first point to remember is that the premium reduction, whatever it may be, applies only to the no-fault claim, the PIP claim, the right-handed claim. You're not given any statutorily mandated reduction in your collision coverage, or certainly in your liability coverage, and you'll see why. Only to the no-fault piece. And the reductions that are being applied are not specific to you. So you may have heard, oh, you know, this particular form of coverage, I get a 35% reduction or a 25% reduction. it isn't 35% of what you paid last year. It is the average for the premium charged by your insurance company that was in effect last year. So where you fit into that average remains to be seen, but don't think that if you select one of these levels of coverage that you can just take your old premium and reduce it by 35%, because that's not the way the law is written. All right, I'm going to talk about some options now. That it's important to pay attention here because these are the options that apply to everyone. Every person has a choice of these first three. And the good news I have for you is that if you so choose, you can choose the old two-handed system. Kind of. We have a problem over here that we're going to talk about. But I guess I should say you can choose the old right hand. That means you can choose that unlimited medical expense coverage that would cover you and your family, they live with you, for the rest of your life if you were in a car accident. It applies to the person named in the policy or their spouse or any other relative who lives in their home. So it's not just kids, but it could be parents, could be aunts and uncles. Anyone who lives in the home would have this coverage available to them. So that's the lifetime option. That's what I'm purchasing. The next option available to everyone is the $500,000 option. Again, it's a $500,000 cap on the medical expense benefit. Somebody asked me once, why does it go from unlimited to 500,000? Can't we get, a couple million in between somewhere? I don't have a good answer for that. The way it was set up, you drop from lifetime to 500,000. Again, available to any person, meaning it doesn't matter what kind of other insurance you have, other kind of health insurance, and it applies to you and any other family member living with you. The next step down in terms of caps is the $250,000 option. Again, I don't know why you can't have somewhere in between, but this coverage applies to any person regardless of their health insurance, and if somebody purchased it, it's the limit that would apply to their medical expense benefit, and that limit would apply to them, their spouse, and anyone living with them. Most significantly here, one of the things that troubles me is that children are implicated in these choices, even though children don't really have a choice. So if somebody chooses a $250,000 limit and their child is injured and their child needs medical care, the child is going to encounter the $250,000 cap. There's some murmurings about changes to that, but I wouldn't hold your breath. Okay, you don't have to read this because you probably got something like this in the mail. One of the things that this statute did is it said that the Department of Insurance and Financial Services, what used to be called the Insurance Commissioner, the acronym is DIFS, that DIFS was required to put together a form that every consumer was going to get, and that was the form that was going to be used for people to make their decisions, make their elections, to when they're working with agents like Mike. What by and large I think has happened, and Mike can clarify I get this wrong, but most insurance companies have taken the DIFS form, they've put their logos on it, and they've sent it out to all of you and said, here you go, let us know what you'd like to do. So this is a portion of the form that you'll see under Section B. Those are your three choices for the coverage levels that apply to anyone: unlimited, 500, and 250,000. One of the other choices you may have to make, depending on your insurance company, is whether or not you want to purchase what is called coordinated coverage or uncoordinated coverage. What is that? Sounds really confusing, and it kind of is, and these names are not very helpful. The concept here is who pays first. If you're involved in an automobile accident, does your auto insurer pay first, or does your health insurer pay first? I have always purchased, and I always recommend to people that they purchase uncoordinated coverage, which seems uncomfortable because we spend our whole lives as kids trying to be coordinated, and then some lawyer tells you to buy this thing called uncoordinated. Well, I found after handling these claims for years that it is much easier for injured people to be dealing with only one insurance company as opposed to two. So when you choose these coverage levels, you may also have to make a decision about what we call coordination. Some insurance companies are not offering coordinated policies at these $250,000 or $500,000 levels, but that's not true across the board. Here's a part of the law that I've always struggled with because I just don't think it's fair. You remember when we started talking at the beginning and I said, where do people go for their no-fault coverage, for their medical expense coverage? The general rule is that people go to their own insurance company. But do you remember I said kind of quickly, well, there's a couple exceptions. And I want to talk about these exceptions because there may be some of you on this call that's going to apply to. These are exceptions to that rule, meaning these people don't go to their own no-fault insurance company. If they're in a car crash, they go to someone else's. So the most common examples that I see are these two: motorcyclists and what the law calls employer-furnished vehicles. You probably think of it like I do as company cars. What about the motorcyclists? Well, since the beginning of the no-fault law, motorcyclists were treated differently. If a motorcyclist is involved in an accident with a motor vehicle, a car accident, the motorcyclist is entitled to no-fault coverage. But they don't go to their own no-fault insurance company first. They first go to the insurance company of the vehicle involved, what I sometimes call the striking car. So even though the motorcyclist may own a car and may have auto insurance on their car, if they're involved in an accident with somebody else, they draw their no-fault benefits from that someone else. The same is true for people in company cars. If you're occupying a company car and you're in a crash, you don't go to your own personal no-fault insurance company. You go to the insurance company that insured the company car. Now, these were weird rules before because it forced people to get their insurance through entities that, through companies that they didn't elect to do business with. You know, all of a sudden they'd insured themselves through auto owners, and now they get in a motorcycle accident and they got to go through State Farm. And that was off-putting. But in the end of the day, it didn't substantively change things because remember, everyone was entitled to receive the unlimited medical expense coverage. Well, the legislature, in my opinion, in its haste, didn't address this problem because these rules still exist. So what that means is that if a motorcyclist chooses what I'm going to choose, they're going to choose unlimited coverage, and they're out on their motorcycle and they get hit by a drunk driver, and the drunk driver chose the $250,000 option, the motorcyclist is stuck with the $250,000 limit that the drunk driver chose, even though the motorcyclist made his own choice to buy unlimited coverage. Now there's an example where somebody made a choice and they can't ever exercise their choice. The same is true for people in company cars. If their employer picks the $250,000 level, but they decided personally that they wanted the unlimited, they're stuck with the $250,000 level. All right, I'm going to move on now to the options that I say are available to some. And why do I say some? Because these are options that are available to people depending upon their health insurance. And we start first with the one that I think is the most confusing and perhaps the most concerning. It's often called the qualified health insurance opt-out. It's got other names for it that make it even more confusing, but here is the basic concept. People who have health insurance that covers automobile accidents can go through a process when they're selecting their auto insurance that will lead to them completely opting out of that medical expense no-fault coverage. They select this 250 level, but then they get an exclusion. So at the end of the day, they say, I've got health insurance that's going to cover me for an auto accident. I'm opting out of no-fault entirely. Now, one of the things that I think is going to be administratively very difficult to figure out is, does your health insurance cover or not cover auto-related injuries? I don't know if any of you have ever tried to get a copy of your health insurance plan, not the booklet you get when you renew, but like the actual plan, sometimes 60, 80 pages long. It's not easy. And when you get it, it's not exactly a thrilling read. And it's sometimes hard to figure out exactly what is covered and what is not. But here's the problem that I see, and I admittedly see the worst case scenarios, but what if someone is injured and they lose their health insurance because they lose their job. And that happens a lot. People can't come back to work. The employer holds their job open for as long as they can, but eventually the employer fills the job. I had this happen 2 weeks ago. Well, if you lose your job and you can't afford to COBRA your insurance coverage, and you can't afford to go on the Affordable Care Act exchange and buy a health insurance policy, then what are you left with? Well, you've opted out of no fault to begin with. Now you lose your health insurance because you can't afford the COBRA premiums or you can't go buy another policy. And so there's only one place left to go if you're not a Medicare recipient, and that's Medicaid. And in order to be eligible for Medicaid, you have to have basically spent everything you have. And this is what I find to be the most concerning, because you will not be able to go out and buy a no-fault policy after the crash and say, hey, Mr. Insurance Company, would you mind insuring me for the no-fault benefits for the crash that happened 6 months ago? That's not how insurance works. So you're going to be stuck relying upon other forms of health insurance. And as we know, in this country, so much of that is tied to people's employment. And people's employment become affected by serious injury. It shouldn't be, but it happens. I'm going to steal this from Mike, because I know he's turned this over to me. But this is the section of the form that explains to you this health insurance opt-out. And Mike said it the best. Don't even necessarily right now bother to read all those words after risks, but just look at how many there are. There's like a half a page worth of risks. And if you go back to the coverages available to all, there's nothing like that. And look at the benefit. The benefit is you may pay a little bit less for the medical benefit, but you've got all these other risks that you're taking on. And if you just look at the words on the page, that should tell you what is obvious, which is that this is risky. Coronavirus proves the point again, right? People losing their jobs, in this case, nothing to do with a motor vehicle accident, but losing their jobs, losing their employment, losing their health insurance. Where would those people be if they had opted out? In a bit of a mess. Okay, the next two options apply to people who are on Medicaid and Medicare. For people who are on Medicaid, they can select the lowest limit, $50,000 in this medical expense coverage. They have to be covered under Medicaid, and someone else and everyone else in their house has to either be covered through Medicaid or have coverage through a different policy. Once they cap out their Medicaid option, they're done with once they cap out their no-fault option, they're done and they're back entirely on Medicaid. What about Medicare? Well, people who are on Medicare can opt out entirely of no-fault if they're covered under Parts A and B of Medicare, and if others living in their household either has Medicare coverage or no-fault coverage, they can opt out entirely. Some people have said, okay, well, I'm a Medicare recipient right now, been working for me, it should work for me in the future. I'm going to opt out. What's the concern that I see? Well, the concern that I see, again, from the perspective of representing people who are seriously hurt, is that people don't think, when they haven't been seriously hurt, they don't think about what kinds of care they would need if they were seriously hurt. So here's a chart. This is put out by CPAN, the Coalition Protecting Auto No Fault. And what it does is it compares those types of services that are covered under no fault and those types that are covered under Medicare. And I'll simplify it by saying, if you think about this, to use the metaphor of a pizza, if the pizza itself represents the scope of benefits that are covered, then Michigan's no-fault insurance system is the biggest pizza you can buy. There's the most amount of coverage. If you go to commercial health insurance, now you maybe have a medium-sized pizza. You go to Medicare, maybe it's a little less. By the time you get to Medicaid, it's a tiny little pizza. And this proves that point. There are all these things: long-term residential care, in-home attendant care, housing accommodations, all these things that people don't think about needing when they're not seriously injured that all of a sudden they do need. And if these people chose to opt out and rely entirely on Medicare, then that's what they're going to be stuck with. Okay, I'm going to skip over a couple of these because I'm mindful of our time. People can purchase additional coverage for what is called attendant care. If people have questions about that, we'll address it in the Q&A. I simply raise the question of if you're going to buy other coverage for attendant care, maybe it makes a better idea to just buy more overall coverage, because this is coverage limited entirely to one form of service called attendant care. There is another form of policies that I'm not aware of being sold yet. They're called managed care policies. If you see them, my personal opinion is stay away from them, because the basic concept here is that you will be forced to treat with an insurance company network of medical providers, and the insurance company entirely will be responsible for monitoring and adjudicating all of your care needs. And if you're someone like me who believes in the ability of the individual to drive their own care, this is a dangerous option. It's a trap, as they say. Okay, this is a deck page. You can look at one of these if you're on, you probably have them in the drawer. I just want to draw people's attention to what you're looking at here. This right hand is what I'm referring to as the PIP coverage, the no-fault coverage. It's just one line of many forms of coverage that people purchase. So this particular person was able to get, for $162.20 per premium period, lifetime medical and 3 years of wages. That's a pretty good deal. What if they chose something less? Well, this slide is illustrating what I said earlier, that if you look at that $162.20 and you assume a statewide average reduction, this person might end up saving 56 bucks, which I think begs the question, do I really want to give up lifetime medical care for this thing that could seriously injure me, a car crash, for 56 bucks? Okay, we're back over to the left hand, the bodily injury claim. You have some choices to make here. The law sets a default limit of $250,000 per person, but not to exceed $500,000 per occurrence. Meaning that if you cause an accident and there's one person involved, that one person can claim up to $250,000 under your liability policy. But if there's 4 people involved, they got to split up the $500,000. This is significant because the old limit that's been around since the 1960s was $20,000 per person, but not to exceed $40,000 per occurrence. So that's more than 10 times more. Why is the law taking up people's default limits higher? Well, because there's a whole new set of liabilities that every Michigan driver has incurred as a result of the changes in the law. People can opt out of this default limit and they can drop all the way down to $50,000 per person, $100,000 per occurrence, which in my opinion is very, very risky. But even there, they cannot drop down to the old limit of $20,000 and $40,000, because in this system, everyone has liabilities that they didn't have before. And this really is the big picture. These limited auto insurance policies, the no-fault policies that I've been talking about, they impose various monetary caps, whether it's $500,000, $250,000, $50,000, or remember, out-of-state residents, 0. Okay, what happens when those people who choose those limited policies, if those people are the victims of an automobile accident caused by someone else, when those people exhaust their limits, their right-handed limit, where are they going to go for the rest of their medical expense liability? They're going to the person who caused the accident. Simply stated, now, every Michigan motorist, for the first time since 1973, has potential liability for a victim's medical expenses. Every single Michigan motorist. You might think, wait a minute, can't I choose this lifetime option over here? Yes, you can, and I think you should. But you cannot force other people to make that same choice. So if I purchase the unlimited option, and heaven forbid I cause a crash, and the person that I injured had the $250,000 option, once that victim exceeds the $250,000 limit, that victim can come to me for the rest of their medical expenses, for the rest of their life. And the reason that didn't exist before was because of where we started, right? Everyone had in their right hand unlimited no-fault coverage for medical expenses, which meant every Michigan motorist was never liable for a victim's medical expenses. That was the basic compromise of the two-handed system. But the hands don't look like this anymore. They look like this. Yes, there's some things in this hand and some things in this hand, but boy, when you lose and you tap out of coverage over here, you're now over here. So now these two hands are wrapped around each other. And they are that way for all of us, regardless of the, quote, choices that we make. Because every serious injury case is now not just a no-fault case, but it is a no-fault case and also possibly a liability case, which means that every one of us needs to be more cognizant now than ever of the amount of liability insurance that we are carrying. Because we buy liability insurance to protect us financially in the event that we cause a crash. We're not perfect. And we make mistakes, and that's why we buy liability insurance. But before, remember, most of people's liability was limited to this important claim, that quality of life claim, but it wasn't medical expenses. Now it's potentially medical expenses from $1 in the case of the out-of-state resident, or from $500,000 and on in the case of the person who buys the $500,000 cap. But for people who are seriously injured, $500,000 in a hospital or an inpatient rehabilitation center, as you can imagine, goes very fast. That's why my recommendation is to purchase as much liability coverage as you can afford. I've purchased a liability policy. I have an umbrella policy on top of it. If you can afford to do that, I recommend that you do it, because we all have more liability now than ever. To use one more metaphor with you, think of this as a balloon. What's in the balloon? The balloon has in it the things we started with, which is the harms from an auto crash. You put all those harms in a balloon. If I push on one side of the balloon, the air doesn't just disappear. It just shifts to another side of the balloon. And that's what we've done here. We've pushed on the no-fault side of the balloon, which means we've pushed that liability over to the tort liability side of the balloon, but it's all still there. All right, with that, Mike, I'm going to stop my share and turn it back over to you to moderate our questions.
Thanks so much, Tom. We have, I don't know if we have 20, but we have a lot of questions. So I'm gonna ask you to try to be as brief as you possibly can. Tom, you still have your mic open, I hope. So
Yep.
Here's our first one. This comes from Diane. I have 2 children, 20 and 21. Is it better to have their car and car insurance in their name to avoid being sued as their parents if it is in our name?
Generally speaking, the answer is yes. Mike, you can tell me what you think, but I think you want the named insured to be the person who is driving the car. You don't, and the cleaner that is, the cleaner the issues will be in the event that there is a serious accident. Mike, add to that if you want to clarify, but I think the short answer is yes.
I think that anybody that you allow to drive your car, whether they're your children or not, you are somewhat responsible for, or at least we're going to make that determination when we go to court, how responsible. If you allowed somebody to drive your car, for example, and they were in a state of mind that a normal, rational person, reasonable person wouldn't allow them to get behind the wheel, you absolutely could be held responsible. Not being an attorney or a judge, that's my opinion. From Beth, her question is, my husband is issued a work truck. Tom, you talked about employer furnished vehicles. I, for example, my business provides me with a vehicle, so this question is important for people like me. My husband is issued a work truck out of Kalamazoo. He often works out of state with it. What happens if he's in an accident with the work truck? Does our personal insurance cover his PIP? Does it matter which state the accident would happen?
Okay, that's a really good question, and it's a tricky one. But let me try to touch on some basic concepts there. For no-fault coverages, this is the exception I referred to. If you're an employer-furnished vehicle, your husband will turn to the insurer of that vehicle for his no-fault coverage. If he is out of state, then he very well likely will still turn to that same insurer, the insurer of the truck. However, he may not, depending on the circumstances of the accident. So here's my advice. One thing that still exists under the law is that if you are a named insured under an auto no-fault policy and you are involved in an accident out of state, you will be provided that no-fault coverage. So if you purchase that unlimited coverage and you're involved in an accident in Florida or California, you're going to get unlimited no-fault coverage for the rest of your life. So as a backstop here to this question, if this gentleman had his own no-fault coverage, if for some reason the insurance company responsible for the no-fault was not the insurance company for the employer, it would ultimately go to your own insurance company, in which case you want to, if you can, have selected the unlimited coverage to take care of those medical expenses.
Okay, great. I have another question from a parent. Her question is involving her minor children who live with her. In the event of an accident while riding in my vehicle, but my parents are driving, we do not live with my parents. How about the following scenarios? Whose policy would cover my children if they're riding in my parents' vehicle versus my vehicle? And what if the accident was my parents' fault? What if, this will all get to order priority, Tom, so I'm just going to finish this up, but what if it were the other driver's fault? Whose policy would cover my children if they were riding in my vehicle, but my parents were driving and the accident was my parents' fault versus the other driver's fault? Thank you, Tricia. Go ahead, Tom.
Okay, so there's a lot packed in there, but it gets to one core concept. When you're talking about no-fault coverages, remember, no-fault coverages are the ones that include your medical expenses. So you're entitled to those coverages regardless of who's at fault. That's why they're called no-fault benefits. The basic rule is that children draw their no-fault benefits from the relative with whom they live. And who's that relative 99% of the time? Mom and dad. So I have a son and a daughter. If they're involved in an accident in their grandma's car, doesn't matter what grandma purchased, they're coming to my policy for their no-fault benefits. And by selecting the unlimited coverage, I've ensured that basically, no matter whose car they're in, certainly grandma, they're coming back to my policy for no-fault coverages. So children are protected by way of their parents' choices, but it also means that children are more vulnerable because if their parents choose something less, then they will not be able to undo that choice.
Tom, this is a question that is very important about people who are currently on PIP claims. Catastrophic claim already occurred. So the question from April is, I was hit head on by a drunk driver in 2013 and had multiple injuries that are still affecting me today. I have PIP benefits from my auto insurance, which covers all of my medical appointments that I have that are connected from my accident. Will I lose these benefits with the new changes? Also, my claims adjuster scheduled me an independent evaluation to see if I still have medical issues stemming from the accident. Does this mean that they're trying to take away my services because of the upcoming changes to the law?
Okay, couple points that apply to everybody. If you have a no-fault claim that exists before June 11, 2019, there is nothing in this law that will reduce the amount of benefits that you can get in total. In other words, no unlimited coverage and non-drop down to 500,000. That doesn't happen. There is one important and I believe very unfair limitation in this law that applies to existing claimants, and that is family provided attendant care. The question doesn't directly ask about this, but let me address it. In very serious injury cases, it is very common for one family member to take care of the serious injured one. And oftentimes families will make significant lifestyle choices, like a wife or husband will quit their job to take care of their spouse or their child. Under the old law, those family members could be paid a fair market hourly rate and there was no arbitrary limitation on the number of hours they can be paid. Under the new law, and this applies to existing claimants, which is why I believe it's very unfair. Under the new law, family members who render care to other family members cannot be paid more than 56 hours a week. If they work beyond that, and many of them do, then they're either working for free or they have to try to work something out with their no-fault insurance company. The last part of this question dealt with medical examinations. I don't like to call them independent because I too often have the experience of them not being that way. But this part of the law changed a bit, but it didn't change the right of a no-fault insurer to say to an injured person, you have to go to a physician that we select, and that physician can render opinions about your care needs. There are changes in the law about who is qualified to do these type of exams, and those changes are effective as of last year, but no-fault insurers have the right to send injured people to examinations by physicians.
Okay, Tom, you've kind of covered this a couple of different angles, but the question is about bicyclists and pedestrians. I'm particularly interested in how the new options will affect bicyclists in an auto-related accident, and if you could also throw in pedestrians and also accidents out of state. So I'm assuming maybe I'm riding my bicycle out of state on vacation and I'm involved in a car accident.
Okay, for cyclists and pedestrians, the rule is the same. If you purchase no-fault coverage, that coverage that you purchased is going to cover you in the event of an automobile accident. So if you're hit by a car on your bike, or you're hit by a car walking across the road, and if you purchased unlimited coverage, you're going to be able to access that unlimited coverage. That same rule applies even if you're riding your bike out of state. I represented a man who was terribly injured in Phoenix when he was run over in a crosswalk by a drunk driver. But he was insured and had an unlimited no-fault policy, and he will have access to those benefits for the rest of the life, even though it was a drunk driver who ran him over in another state.
Okay, can you explain how this, the changes to the law, affects seniors? I have heard different information about Medicare and auto coverage. Thanks, Carolyn.
Okay, so we did touch on this. It affects seniors because obviously seniors are the ones that are the most eligible by virtue of their age for Medicare. So seniors are the ones who are going to be asked, do you want to opt out of no-fault coverage entirely? You want to rely entirely on Medicare? And I explained earlier with the chart, the general concept is that no-fault insurance provides a much broader scope of benefits and the kind of benefits people need in the event of a serious injury, much broader scope than what the Medicare system provides. So that's the choices that seniors are going to have to ask. Do I want to rely on Medicare entirely and take a risk? Or do I want to buy no-fault coverage to take care of me if I'm injured in a car accident?
Okay, this next question says, is there any coverage that can be purchased to insure passengers, for example, the elderly or under 16 years old with no policy of their own or non-licensed drivers in the event of a catastrophic accident, or is their medical max $250,000, even if I've purchased unlimited?
That's a great question. I'm going to pitch a little of that back to you, Mike, if you don't mind.
Sure.
I can tell you from the legal standpoint, if the person is a named insured on an auto insurance policy, and Mike's going to maybe address how they become one, but if they are a named insured on an auto insurance policy, then they will have access to whatever level of coverage that policy provided. So if it's unlimited, the underage person or the older person gets access to the unlimited coverage. I think there's also a practical question built in there about how do those people get on policies?
Yeah, we've talked about this a little bit, but to try to make it as simple as possible, if you're injured in an accident, let's say you are treated, it's over, you're done, and your hospital, as you're walking out, your hospital says, oh, here's the bill. Who's going to pay this? So that bill has a name on it. If that name on the top of that bill, or whoever's responsible for the bill, whoever was injured, I should say, if their name's on the auto insurance policy, they're what we would refer to as a named insured. Their name is actually listed on the top of the policy. So we would also refer to that as you. So the first thing is, the first question the hospital will ask is, do you have auto insurance if you're involved in a car accident? If the answer is no, I don't have a policy, okay, then the second step to try to figure out who's going to pay that bill is, do you have a spouse that you live with that is covered on an auto policy? If the answer is yes, okay, then that's the policy we're going to go to. If the answer is no, then we go to the next question, okay? I don't have a policy, so maybe I'm an elderly person living with my adult children, or I'm an 8-year-old child. My spouse doesn't live with me. They don't have a policy. So the third step is, are you domiciled with any resident relatives? So if you're a child, like Tom said, you more than likely live with a parent, not always, but sometimes. If you're a non-licensed driver, you have an elderly parent, for example, that lives with you. You take them to church, and on the way to church or the grocery store, you get involved in a car accident. Doesn't matter who's at fault. If they live in your household and they're a relative of yours, they're covered on your auto policy. The important question that I've had come up before in these talks is, what about my elderly retired parent who lives in an apartment by themselves and they don't have a license? Can I buy car insurance for them? So the answer is no. The only people that can buy car insurance are qualified licensed drivers. What's also important to know, and this is really more important for the other end of the age spectrum, is let's say in the city of Detroit, you live downtown Grand Rapids, you rely on public transportation, you have a driver's license, but you don't have a vehicle that you own, so you don't have auto insurance. It hasn't been as big of a deal in the past because the way the old law was structured, if you got into a car accident, the law was structured so that somebody, the car you're riding in, whoever was driving the car you're riding in, somebody was going to provide for your medical care. The law changed that. So if you have a 24-year-old child, for example, that doesn't own a car, has a driver's license, doesn't live with you, they're out on their own, they rely on public transportation, they walk to work, they Uber, whatever that it is, that person is still uninsured under the new system. The way they fix that, assuming they don't have health insurance, the way they fix that for PIP coverage is they call their agent and they ask about what's called a named operator policy. So think of that policy as being a vehicle that's just insuring you. If you were to drive any vehicles, you were to borrow my car for liability as well as for your medical care. There's no vehicle to insure or anything like that. We've often referred to this sort of as PL and PD before. But that's the idea, that you could be uninsured and not have a vehicle at all. So unlicensed drivers cannot buy auto insurance. And let me get to our chat here real quick. Okay. Tom, how are you doing for time?
I'm good.
Okay. Okay, so Medicare and uncoordinated. With Medicare plan, should uncoordinated be chosen?
Oh, it's a great question. It almost has to be, because Medicare under federal law is always what we call a secondary payer. Matter of fact, there's a federal statute called the Medicare Secondary Payer Act, which says Medicare always pays second. So if you're purchasing if you're on Medicare, you're going to have to purchase an uncoordinated policy because Medicare will not coordinate with auto.
Okay, let's stay on Medicare for a second. Michael asks, if an insured is a Medicare recipient, should that individual select a higher medical coverage limit because Medicare, even with Medicare Advantage, might not provide full coverage? For example, attendant care, replacement services, or staying in a nursing facility. So the question, Tom, and this has come up a couple of different times, people are reading, particularly from Director Fox, has come out quite often and said, if you're on Medicare, all of your bills should be covered. You really don't need to buy auto PIP coverage. And so maybe you could address that a little bit.
Yeah, and I think we touched on this before with that chart. Sure, if you're on Medicare and the service you want is covered by Medicare, Medicare will pay. But if there are services that you want to access that Medicare doesn't cover, and there are a lot for people who are seriously injured, then people will not have access to that type of medical care because they will be relying entirely on Medicare. I mean, for example, people have heard of Medicare imposing numbers of days that people can stay. in a nursing home, or not permitting in-home nursing care or in-home attending care. Those are the kind of things Medicare doesn't cover. And if you opt out of no fault, then you won't have access to that form of coverage because it's just something Medicare doesn't pay for.
Yeah, the other example that we'll oftentimes bring up in our agency that people will get right away is invariably someone has heard of or knows someone who was involved in a catastrophic accident, maybe with an auto, maybe not, but they needed to change their home to be handicap accessible. Hallways
Right.
needed to be widened, bathrooms need to be changed out. If you've ever renovated your bathroom, you know that's not inexpensive. If I have 2 steps, for example, to get up into my house from my garage, I have to install an elevator or something in order to get that done. I may have to have a vehicle. I've got to buy a handicap accessible vehicle that, for example, my wheelchair could drive into. Health insurance, doesn't matter if it's Medicare or Blue Cross or any other health insurance, and it's not a good or a bad thing. Like Tom just said, health insurance doesn't do that. That's exactly what your PIP coverage does do. Tom, this is a question from Amy. It's a really good question from the standpoint of the provider, but I think it's an important question to understand as a consumer. So Amy asks, she's a private practice owner. What is in place to keep track of clients' paid expenses? How, as a provider, do I know if they've met their cap or are about to? This could be severely detrimental to providers and or clients if we cannot know this information.
Oh, this is such a good question.
I knew you'd like this.
And this underscores I think, indefensible shortcoming of this law. There is absolutely no guidance in this law to answer that question. How do providers get paid when a victim has a capped policy? Doesn't say anything. So Amy asks a great question. I mean, here's the sequence of events that I see every day. Somebody gets a serious wreck. They get a ride to the hospital. I'm from Grand Rapids. They go to Butterworth. They have surgery. They're in Butterworth for 5-6 days. They leave Butterworth. They go inpatient rehab at Mary Free Bed. They stay at Mary Free Bed for, say, 2-3 weeks. Then they see their therapy and so on and so forth. Okay, by the time they get out of Mary Free Bed, there's a lot more than $250,000 worth of medical bills. Guess what this law says absolutely nothing about? It doesn't say who gets paid first. It doesn't say how much each person gets paid. It doesn't say it's first in, first out. It doesn't say pro rata. There's no guidance on that. And that is going to be another part of the chaos that this law has created. And I wish for Amy, the person who asked the question, that there was a good answer, but there really is not.
So what this does bring up, Tom, is the other hand that you've talked about. So first of all, confirm for me that if somebody chooses a limited benefit, like the 500 or the 250, do they, if they use up that money, do they have access to the assigned claims plan for an additional $250?
No.
250,000. No, they don't. So the problem, guys, if you're listening to this, who's going to now be paying that, Amy, the provider? I am. If I cause the accident, they're going to be sending me the bill. They're going to get somebody like Tom that's going to say, well, I'm really sorry, but my client has extinguished their benefits, and Mr. Salisbury, you caused the accident, and we would like to be able to look at what type of liability coverage that you have. When I talk about liability coverage, and I know we're spending the majority of the time talking about PIP medical coverage, that's coverage that pays our bills. But I think one of the glaring, I don't want to say problems, it's just a risk with this law, is how much more liable you are, I am, Tom is, to be sued if we are the cause of an accident. And I'll tell you exactly how that gets determined without getting into Tom's legal talk. If you've ever been in a car accident and the police get called, one of the people that was driving a car, one of the people is going to walk away with a ticket. And that ticket is going to say whether they're more than half responsible. So that is the person that is at fault, at least from the insurance world. And so that's the person that better make sure that they have a significant wall of liability built up between the other party and your assets. That's why liability is so important. We've never been able to be sued for someone else's medical bills. We can now, and that's already happening. And like Tom said, with out-of-state people, being in Michigan, they used to be able to tap into our unlimited coverage and they can't anymore. So talk to your agent about that. Tom, another question. Is it possible that instead of getting a discount on my PIP portion of my policy, could we actually see an increase if we still choose the unlimited option? And Tom, I'm going to go ahead and take that one because it isn't necessarily a legal question. The answer is possibly. I would say in general that's unlikely. The fees that we all pay into, those fees are cut in half roughly for people that choose the unlimited option. For people that choose anything other than unlimited option, those fees go away after July 1st. So it would be really difficult for me to figure out how somebody's insurance could go up. However, if you have a violation, for example, let's say Tom's example, your policy renews in September, your insurance company mails you the forms, you call your agent, hey, I'm trying to make a decision on what's best for my family, and you send the forms back in with unlimited coverage. End of July, you cause a car accident. Doesn't affect your current policy at all, doesn't affect your rates or anything like that, but you are a riskier driver, you have an at-fault accident. So on your new policy, you would always have probably, I shouldn't say probably, you would have seen some rate effect because of that violation. So that's a possibility. Here's the other possibility. Some insurance companies use rating factors like your gender, whether you own a home, what your education background has been in, all to offer you discounts. Though the law changed that those cannot be used anymore as rating factors. So you could potentially be in a situation where an insurance company is forced to remove some things that are unique to you that saved you money. But the law took those things away, and the idea being more fair for everybody and more transparent. So that's the other way that I could see your premium increasing if you chose unlimited option, but I don't think that's going to happen to most people. Individual who lives in the same house, does this include a college student, Tom, who lives on campus?
Oh, gosh, I was just talking about this with one of my law partners earlier this week. I'm going to give you a not so sure answer. We're going to be fleshing this out for a long time because where college students live, where their residence is, where their domicile is something that I think we're going to see more and more debate over as we get into this law. I think the most likely scenario is that a college student, particularly, and Mike can address this from the insurance standpoint, but I think most likely a college student who is in their first few years of college, who's going to college and coming home on the weekends or coming home in the summer is going to still be considered to have a domicile at their parents' house. What concerns me more are situations where kids go out of state and maybe it's beyond college, but it's into grad school, or maybe when they get to out of state that they make a lot of attempts to try to establish in-state residency for a variety of reasons. All of a sudden, that pushes up against the thing we talked about an hour ago, which is out-of-state residents being disqualified from no-fault coverage now. So I think, and Mike, correct me if I'm wrong, the short answer is probably most college students in a traditional setting, they're going to be able to draw under their parents' policy, but there are certain fact situations where that could change.
Tom, I agree with everything that you said. Insurance companies, and we still have to flesh this out, we're going to have claims that even insurance companies are going to have to get help with interpreting this law. So Tom, this is a specific question that I'm hoping you have some background in. I don't, about brain injuries. Amy writes, this is an acronym, CARF, a CARF question. What is being discussed regarding everyone needing CARF? If I'm saying that correctly, I apologize, Amy, if I'm not. There are other options that would encourage better care for persons with brain injuries and or spinal cord injuries, such as certifying brain injury specialist certification. CARF does not address making sure the providers are providing the best care. It's more about policies and procedures and administrative. Are you familiar with CARF at all, Tom?
I understand what this is getting at, and it's a little
Okay.
technical, so I'll be brief, but I can talk offline with people who want to talk about it. But there's a whole other section of this law that we have not gotten to, and it's the phase that kicks in next year. And it's the part of the law that imposes mandatory fee schedules and fee reductions on medical providers. Many of them, the way the law is written right now, are being forced to take a 45% revenue cut. Many of them will not survive that. Within that fee schedule, a section of the law says that there are certain providers who provide brain or spinal injury cord care who cannot be paid at all if they are not accredited through an entity known as CARF or a similar entity. So what the question is getting at is CARF really the right way? And I think that's a discussion for a different venue, but what bothers me about this question is it gets at the effects that we haven't even seen yet, and we won't see till next year. We're starting to see some of it on the medical provider community, because this law imposed medical providers with a very, very strict fee schedule. So many of them are going to have to figure out how to operate with a whole lot less, and many of them won't get paid at all. And that raises questions about how medical providers are going to be able to stay in business. So that's what that's getting at.
I want to be cognizant of everybody's time, Tom. We've really retained almost 100% of the people that started the night with us, but I want to wrap this up fairly soon. How does the law affect driving, or I should say riding, in a taxi or Uber?
Okay. This is a tricky one. And
sorry about that.
That's okay. So my best advice here is choose your own destiny by having your own policy. Because the way that the law works now, as best I can understand this portion, is that if you choose your own destiny, meaning you pick a policy like an unlimited policy, then you're going to be able to access that if you're in Uber. If people have not, then it becomes more complicated. But for now, you can choose to not have that problem.
Okay, thank you, Tom. Where do we buy extra liability or an umbrella policy? Through our auto company or somewhere else? And I'll I'll answer that one.
I'm going to jump in and say you buy it from Mike. He's not going to say that.
I would talk with your auto insurance company or your homeowners, renters, condo, farm, whoever is writing those policies more than likely can write you an umbrella policy. And as Tom said earlier, I would buy as much liability coverage as you can afford. What if I spend most of my time driving out of state? So this is a Michigan resident who spends most of their time driving out of state. Tom, can you talk a little bit about how bodily injury and PIP coverage would affect this person?
Sure. So again, this is the same rule we touched on earlier. If you are a named insured in an auto no-fault policy, the right-handed policy, and you're injured in an automobile accident out of state, you're going to be able to access those PIP benefits that you purchased. So again, choose your own destiny and know that the destiny will follow you for your medical care when you're involved in an accident in another state. If you're going to be out of state a lot, my recommendation is that you purchase as much liability coverage as you can afford, which is now the recommendation for Michigan, because most other states, pretty much every other state, has a system where you can be liable to the victim for medical expenses. Now, again, Michiganders didn't so much have to worry about that really at all, because within the state, we knew that everybody was protected. But if you're in another state, you're already sort of getting a preview of what life is going to be like here in Michigan. And I would recommend you buy as much liability coverage as you can afford, because most other states have legal tort systems where the victim can pursue medical expenses against you if you cause the accident.
Okay, Tom, from a mother, Crystal asks, what if you're in an accident with someone else's kid, like in a carpool situation?
If That goes back to our same rule about kids. Kids draw their no-fault benefits from the insurer of the relative with whom they live. Succinctly stated, for the most common example, mom or dad. But if the child is a passenger in someone else's car and the driver of that car causes an accident, the child will look to his or her parents or whatever other relative they live for the no-fault benefits. But the child may also have a liability claim against the person who was driving the car. Anytime you have a passenger who is injured, the passenger likely has a liability claim.
Can we stay on that topic, Tom? Can you talk a little bit about how uninsured and underinsured motorists, Darcy asked a question, what about uninsured motorist coverage? So this is a rarely used but often included coverage that is in almost every auto policy. I say almost. Can you talk a little bit about how the law will trigger uninsured motorist claims?
Okay, I'm going to cut to the practical point, which is that uninsured and underinsured motorist coverage is some of the most important and cheapest coverage you can buy. And that was true before, and it's true now. What's uninsured motorist coverage? It is coverage that steps into the shoes of a bad driver who has no insurance. Underinsured motorist coverage is coverage that steps into the shoes of a bad driver who has little insurance. So let's use me as an example. Let's say I'm leaving the office here tonight and I get hit by a drunk driver and I cannot practice law. Where am I getting, this is a little review, where am I getting my first 3 years of lost wages? No fault. But where am I getting the rest of my income? Because I can't work again. Where does that claim go? That claim goes against the person who caused the accident. And that's always been true. What if that person has no insurance? They are an uninsured motorist. Well, the reason I buy lots and lots of uninsured motorist coverage is for that very fact pattern. If I'm a victim of someone else's negligence, I want to be able to pursue a liability claim against that person. And if they don't have insurance, I buy uninsured motorist coverage and it stands in the place of the insurance that they didn't purchase. Similarly, if I'm a victim of a drunk driver or a careless driver who has a little insurance, I have underinsured motorist coverage that will step in and take over after I've exhausted their little coverage. So these two forms of coverage have always been important. They're all the more important now, but they're cheap. And I recommend, and I've always recommended, you buy as much as you can afford.
In the old law, there was something called PL and PD coverage. We don't really use those words anymore, but everybody sort of understands this is typically what you would ask for with an agent like me when you have an older car that we're not going to get full coverage on. Full coverage refers to paying for damage to the car. So in the old law, Sharon asked, there was something called PL and PD coverage. My understanding of that was that it would not cover vehicle damage, but would cover injuries. Is there a similar option under this new law? And so, Sharon, what you're referring to really hasn't changed. Collision coverage, the damage that could occur to your vehicle or to anybody's vehicle, no fault essentially is I take care of damages to my car, you take care of damages to your car. The only exception of that is what is called a special tort or a mini tort liability claim, whereby I hit your vehicle, I'm responsible in the accident, you don't have any collision coverage, or you do, but you've got a $1,000 deductible. I will be responsible for your out-of-pocket or the value of the vehicle up to a certain amount. That amount used to be $1,000. The new law changed it to just $3,000. Janice asks, what about Canada?
Ooh, that's a good one.
Okay.
No-fault coverage extends to, I was going to see if I could find the statute right on my desk, but it extends to the U.S., its territories, and Canada. So if you're going to Canada a lot, you want no-fault coverage because it treats Canada like an out-of-state situation. If you're driving in Japan or the UK, there's no-fault coverage.
What if a bicyclist is hit but doesn't have auto insurance and is hit by an auto?
Okay, that's what we call the uninsured non-occupant, which means they're a bicyclist who didn't have auto insurance. They now, for their no-fault benefits, they now have to go to the assigned claims plan. They used to draw their no-fault benefits from the car that hit them. Now they go to the assigned claims plan, And the problem now, or the change here, is that when they get to that assigned claims plan, they're going to be limited to $250,000 in medical expense coverage. So what that means for the bicyclist is that after they exhaust that $250,000 in medical expense coverage, the rest of the liability for the bicyclist medical expenses beyond that $250,000 goes back to the liability claim against the driver who struck the bicyclist.
The other hand, right, Tom?
The other hand.
So we're just about done here, folks. We've got, I think, 2 more questions left. If you keep your unlimited policy, do you have to change your liability amounts? And if you choose a limited policy, could you later change your policy again?
Mike, I think I'll let you
Sure.
answer the
Yep,
question.
I didn't know if you wanted to
no, but I'll take the first part,
Sure.
which is that if you choose an unlimited policy, do you need to change your liability policy? Well, you don't quote unquote need to legally, but I recommend, and I think Mike does too, that you should, because this is the same concept we talked about before. You can purchase unlimited no fault to cover you and your resident relatives for your no fault expenses. But if you cause an accident, you don't know who you're going to hit, and you don't know how seriously they're going to be injured. If that person picks a limited no fault option, something less than then that person has a claim against you if you caused the accident for their medical expenses above and beyond whatever cap they have. So that's why it's no longer I bought unlimited, I'm fine. Yes, you're fine to protect you and your medical expenses, but you haven't protected your other flank, which is the liability side. So in that case, I recommend that, and this is the reality of this law, everyone's got more liability, so buy more liability. As to the change piece, Mike, you can address that.
Yes, I think that unfortunately we use these figures, 250,000, 500,000, million, unlimited. As agents, we use those kind of really interchangeably, and sometimes for you that are watching, because we do this every day, we should go a lot slower. I like Tom's hands, okay? So Kathy asked this question. Your unlimited PIP coverage is Tom's right hand. That's paying for all of your bills for you, your spouse, and any relatives in your household. The other hand is what you use to defend yourself, or like I say, build a wall between you and somebody that is trying to get to your assets. They don't have anything to do with each other. Now, the law does deal with minimums that you must have. You must have, if you don't have health insurance anywhere else, you must have to be an insured driver, $250,000 in PIP. That's the third option. The problem is totally different, but the law also says that the default limit for liability protection, when I say protection, I mean protecting you against lawsuits, that happens to also be $250,000. Tom's talked about the assigned claims plan being $250,000. So just make sure when you're talking with your agent that you understand, if you remember Tom's hands, which hand are we talking about? Is this benefits I could receive, or is this a wall of protection so that people can't come after my assets? If I rent a car out of state, does my Michigan car insurance cover the car? Cheryl, none of that has changed. So yes, it should. Check with your insurance company, but yes, generally most policies extend to any vehicle you're driving, whether you own it or not. Kevin asks, what's a reasonable amount of additional coverage? I'm sure that's quite subjective, but what's a good sweet spot for an umbrella you see, Mike? Okay, so Kevin, let me tell you about my situation. Knowing what I know about the insurance industry, in the old system, okay, I carried $500,000 in auto liability. I could have bought up to $1 million. I carried $500,000 in auto liability. I'm married. I have a 20-year-old that goes to Michigan State. I have a 16-year-old that's just about to get her license in high school. So I'm very risky from the standpoint that I have 2 young drivers that just don't have the experience that people like you and I do. I had a $500,000 auto policy. I had a $1 million umbrella policy. The umbrella policy is really nice because it provides me worldwide coverage. It also provides that liability protection over any lawsuit that could be covered under my home. So it literally is an umbrella over my assets. I increased my auto liability as of July 2nd. I called my agent. He's a really good guy. called my agent and I said, I want to change my liability from 500 to $1 million, essentially doubling it. And then I took my umbrella policy from $1 million to $5 million. So I think most insurance agents that you talk with could get you a quote for $5, even up to $10 million. If you're in a financial position that you need more than $10 million in protection, and some people do, then your agent's probably going to have to go deeper into his company, his or her insurance company, to get those figures for you. A couple people have asked about recording, and then I have one last question. People have asked, is this going to be recorded? It is. It's being recorded now live on Facebook, on our Reno Agency Facebook page. So if you don't already like our page, you like it, you can rewatch it there. We're also going to post it on the Reno Agency YouTube page. And Tom, this will be our last question. Do the changes in the law affect UIM coverage, underinsured motorist coverage, in any way?
No, there has never been a statute in Michigan regarding uninsured or underinsured motorist coverage. It's always been optional. It remains optional, but I can't say it enough. Buy it. It's very cheap. It's usually less than the cost of going to one movie with you and your family. Buy it and buy as much as you can.
And I'll tell you, if your agent is worth anything, don't take this wrong if you don't have it, but the majority of agents that I would know professionally include and underinsured motorist coverage at the same liability limits that you have to protect yourself against a lawsuit. So on and under liability is for you, where bodily injury is really payments that can go to someone else. So I want to just draw real quick that Tom has just reposted again a link before we end the meeting. If you want to click that link to his PDF, it's a wonderful document. Yeah, I won't get into how I met Tom, but Tom's excellent at tearing this stuff apart. So I would really suggest that you look over that. And yes, Darcy, you need a cyclist without their own auto policy would need a non-owner or a named non-owner policy. So if you have any other questions that we haven't covered, you can find Sinas Dramis firm if you Google them. You can do the same thing with renoagency.com. You can reach out to me there if we didn't cover anything. I'm obviously on Facebook. You can find me there if you want to send questions too. But otherwise, I'm just going to thank everybody for coming. I'm looking at our participants. Literally 90% of the people that started an hour and a half ago are still with us. So if you appreciated this, I hope that you did. I hope you learned something. That was our goal when we got going today. And I'm about ready to say goodbye. Tom, if you'd like to say goodbye.
I'm ready to say goodbye. Thank you, everyone, for hanging in there with us. This is great questions and a great discussion.
Take care, everybody.